So we have seen up to section 83, 79 to 83 in chapter 4. Now let's move to section 84 to 93, which is related to the proclamation part. So this chapter had arrest with and without warrant, which we have seen, exercise of power and execution rules, etc. we have seen. Now we'll see proclamation and attachment part, which is the rear end, the last part of the chapter 4 under this particular module, module 3. So section 84 is something which has a title called Proclamation for Person Absconding. So the people who are absconding, a proclamation for them. There is a process for that. So in the court, if the court has a reason to believe whether after taking evidence or not, so at any stage, it's a discretion of the court, that any person against whom a warrant has been by it has absconded or is concealing himself so that such warrant cannot be executed. So either the person for whom a warrant has been issued has absconded, has already run away, or is concealing himself in the same place somewhere where so that the such warrant cannot be executed. So he is not letting the warrant happen by concealing himself by any way. So such court may publish a written proclamation. Then the court has to make a written proclamation. As I said yesterday also, what is the literal meaning of proclamation? To make a formal announcement. So the court may publish. So the court has to publish. The moment publish comes, they have to write and publish in various mediums. It's a written proclamation. So the court has to may publish a written proclamation requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publishing of such proclamation. So if such a proclamation has to be published by the court, if believe it has to be done in the case where the person is absconding or has concealed himself, the court will go ahead and publish. The court may publish a written proclamation to make that person know that for so and so place and so and so time, you have to appear and within the 30 days of publication of that proclamation. So within 30 days, he has to make himself available in that particular place and go and report in that place. So this within 30 days, so not less than 30 days from the date of publishing of such proclamation, the person has to go and appear. Now, the proclamation shall be published as follows. Now, when we see the publication has to happen, how the publication will happen. So 1A, it shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. So it has to be put in certain town or village places where he might get an awareness of that particular publication. It is publicly present. So you print it and paste it in those places where the person can read it, which is mostly possible to be put in his own locality, building, house, bungalow, shop, office, or in the village in certain places near his house, etc., etc. And B says it shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides or to some conspicuous place of such town or village. So it shall be publicly read in some conspicuous place. So the first part says it is placed in a place where it could be read properly. The second part clarifies that yes, it has to be pasted in those places affixed on those places in the town or the village. Part C says a copy thereof shall be affixed to some conspicuous part of the courthouse. So it has to be put on the conspicuous part of the courthouse also where such notices and proclamations are put. Under subsection 2, part 2 says the court may also, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper circulating in the place in which such person ordinarily resides. So these places where it has to be affixed or the places where it has to put affixed in the house or the court or where it is published in the newspaper, it is also understood by default that the person might also get information through somebody of his interest who can go back and inform him and he can also read that. So it fits both the purposes. Now come to subsection 3. It says a statement in writing by the court issuing the proclamation to the effect that the proclamation was duly published on a specified day in the manner specified in clause 1 of the subsection 2 shall be conclusive evidence that the requirements of the section have been complied with and the proclamation was published on such date. So once it is done, so after that activity of the part 1 which is given, which is pasting at the specific places in the town, village, or in close to the house, courtroom, and the newspaper, etc. And all those things, once it is done, the court will publish a statement in writing that this proclamation is completed, the activity. And once the statement is made by the court uh, on records, then this is considered that it is complied with. It is complied. Now, please understand from 1 to 3 until now we have come. The origin of this proclamation of person absconding is through the discretion of the court. There is no such testing condition. There is no such fixed testing condition which is required for proclamation. For the proclamation, the other party has to come back, the person who is whom it favors the proclamation. So if it is proclamation, it is mostly for the accused, which means the prosecution side. The prosecution side has to go back and stand for the proclamation to be effected by the court, because it is a court's discretion. A request can be made. Intention in that direction could be presented to the court to act in that direction, but it does not mean that there is any right which could be claimed by those prosecution side. It is something which is, if it weighs in the direction of the thought of the court might take a discretion around that. But again, there is another catch here is the court is also bound by the basic rules and regulations and the jurisprudence, where if they are not putting a proclamation at a right time, which could be justified by the prosecution, by various case laws, etc., or various logic and the various reasons, then it might be a default on the court as well. So that is why the courts normally do that on the right uh, request and uh, reasons given by the prosecution also. But the court might take its own discretion by default also in this condition. Subsection 4 says, where a proclamation published under subsection 1 is in respect of a person accused of an offense which is made punishable with imprisonment of 10 years or more, or imprisonment of life or with death under the BNS 2023, or under any other laws for the timing in force, and such person fails to appear at the specified place and time required by the proclamation, the court may, after making such inquiry as it thinks fit, pronounce him a proclaimed offender and make a declaration to that effect. Now, the person could be made a proclaimed offender. That declaration can happen in case that person who is punishable with who is committed an offense with so and so number of years, so 10 years or more, life, death, etc., and or under any other law for the timing in force, and such person fails to appear. So if the person has made any kind of such crimes which could be punishable by such durations, the court may, after making such inquiry, if they want to make any further inquiry. So inquiry part we have read already in the CRPC, in the BNSS also. So basically the inquiry where the court might also do it by themselves, or it might engage anybody, a police officer or a third person whom it believes could be inquired in that direction or made to help in the inquiry. So after making such inquiry, if the court receives all the feedback and the details what he's requesting through this inquiry, by doing upon himself or by through a police officer or through anybody third party who is not a police officer, in those cases, after the satisfaction of the situation, the court might declare him a proclaimed offender and make a declaration. So they will publish a declaration of that to that effect through an order. Subsection 5 says the provisions of subsection 2 and 3 shall apply to a declaration made by the court under subsection 4 as they apply to the proclamation published under subsection 1. So the subsection of 2 and 3, what is 2 and 3? 2 is how the publication has happened, and 3 is the court publishing a statement. So the provisions of publishing and making a statement of the publication shall apply to the declaration made by the court under subsection 4. So The provision of 2 and 3 will apply to the declaration made in Code 4 as they apply to the proclamation published under subsection 1. So it has to be applied into the subsection 4 where the proclaimed offender is made, and that is something which is clubbed together. So detailed explanation is basically the issuance of the proclamation is the particular matter which is discussed in section 84. It gives some legal mechanism for courts to deal with individuals who have absconded or are hiding to avoid arrest. To very clear, this situation is only for avoiding an arrest situation. And when a court believes that a person against whom a warrant has been issued has either absconded, evaded, or is evading the law by concealing himself somewhere. So then they can go ahead and publish a proclamation against him. Now, the proclamation must indicate a specified time for appearance, that is not less than 30 days. So giving the benefit to the other party also, from the date of publication, so within 30 days, the person has to make himself or herself appear on the place and the time where it is mentioned. And the method of publication is given in subsection 2, which gives in detail it has to be in a public reading view. So the place which you will select is through public reading view areas in the village and the city, where it could be prominent places, house, bungalow, shop, etc. And number 2 says it has to be affixed as a notice. So it has to be affixed on paper, printed and clearly visible, and published or printed on those areas. And the third point, which is talked about in subsection 2, is the newspaper publication. It could be a newspaper publication also. Subsection 3 talks about an evidence of compliance. So when this publication has to happen, although it is happening by the orders of the court and discretion of the court, but then there should be a evidence which has to be complied with. Compliance of the evidence of the compliance should be presented. So a written statement from the court has to be published, confirming that the proclamation was published as required as a conclusive evidence of the compliance and with the publication process and the date whatever has been followed. So this is a legal accountability basically on the courts and help prevent disputes over whether proper procedures were followed later or not. So it is something to respect the process than the person. So the court might be the judicial officer might change over time, the courts might change over time in different levels of appeal, etc. Then this is something which has to be a paper evidence which should be available on the records, and this is why this is an evidence of compliance which is discussed in subsection 3. Now, consequence of non-appearance, if still that happens, then subsection 4 says if the proclaimed individual who has failed to appear at a specified date and time within those 30 days, particularly for serious offenses, which are more than 10 years, life imprisonment, death, etc., the court may declare the individual as a proclaimed offender after conducting a appropriate inquiry. And this declaration allows for further legal action, including potentially enhanced penalties and stricter local enforcement measures. Applicability of provisions for declaration is given in subsection 5, where say the same rules regarding publication evidence established in the subsection 2 and 3 apply to the declaration made under subsection 4 regarding proclaimed offender. So it has to be clubbed, the same procedure, and the declaration whatever is happened for a proclaimed offender, exactly as the subsection 2 and 3, it has to be published on the prominent places, it has to be published in the newspaper if required, and a declaration by the court has to be made at the end that the person is indeed declared a proclaimed offender on so and so date for so and so reason. So it brings a enhanced law enforcement. Even the person is absconding, but when we have a strong reasons to believe the person is absconding, we can still enhance the law enforcement through this process of declaration of proclamation, proclaimed offender. It can also become a public awareness and cooperation. So that, as I said, the person, when it is published on the locality and on paper, on the walls, etc., or in a newspaper, it is again a public awareness and cooperation also, where the person might be, informed by the people known to him or well-wishers of him, or even at in this case, the enemies of him, they can come back and inform him that you are looked out by the court. There is a look by the court on you for so and so date. Within so and so date, you have to be coming and presenting yourself to that court under so and so matter. So that is also public awareness and cooperation, which is automatically invited by such an action. Then third thing is a judicial efficiency. It increases the judicial efficiency by giving this discretionary power, where if the person is not being able to be found by the police officers in spite of all the measures taken, it brings up an additional effort through the public cooperation and the public awareness, and to making the person aware that these are the consequences if you don't come. And that is why this increases the judicial efficiency as well. And it also shows a very strong legal authority also, that you cannot run away from the clause of the law. If you are running away and trying to hide yourself, you have to better present yourself. Otherwise, these are the consequences within so many days. And there is a potential for increased punishment also if the person is not presenting himself at that point of time, and the person is presented or found or arrested at some point of time later. So this is about section 84. In case of section 85, which is attachment of property of person absconding. So this is the section about attachment of property of person absconding. So the court issuing a proclamation under section 84. So the court which is issuing a proclamation, the whole process of declaring somebody, publishing, and then inquiring, and then finally publishing and circulating that person being a proclaimed offender, that whole process is called a proclamation process. So the court which issues a proclamation under section 84, the previous one which we just discussed, for reasons to be recorded in the writing. So the court has to justify in writing at any time after the issue of the proclamation. So after the issue of the proclamation, once they have declared the person as a proclaimed offender, can order the attachment of that property. So the property of that person could be attached, whether it's a movable or an immovable property or both, which are belonging to the proclaimed person. So the ownership is of that proclaimed person. Provided that where at the time of the issue of the proclamation, the court is satisfied by affidavit or otherwise that the person in relation to whom the proclamation is to be issued. So provided that where at the time of the issue of the proclamation, the court is satisfied by affidavit or otherwise that the person in relation to the proclamation is to be issued is about to dispose of the whole. So in this situation where when the court has already issued a proclamation against that person, and the person holds some movable and immovable property, and then at the time of the issue of the proclamation, the court is satisfied by affidavit or otherwise. So otherwise is first I'll take. So if the court believes otherwise, which when we say otherwise, it is the court's discretion, and or by affidavit. So if the affidavit is made in that regard by some party at the side of the prosecution, that the person who the proclamation is to be issued is number A, is about to dispose of the whole or kind of or any part of the property. So the person might dispose of and run away, or is about to remove the whole or even any part of his property from the local jurisdiction of the court. So the person might be fully disposing of or partially disposing of his property, because the person, if runs away, the only reason the person won't come back is he will have no thing to claim in that particular jurisdiction, movable or immovable, if he's able to part with, run away with everything. So either by taking it with himself, which is a movable property, or by selling and converting it to currency to use it, create a new property somewhere else out in the jurisdiction. So in this case, the person will try to sell part, or at least for survival, the person might be looking to sell some part of it. So in about to remove the whole or any part of his property from the local jurisdiction of this court, it may order the attachment of the property simultaneously with the issue of the proclamation. So at the time of the proclamation, when it is issued, at the very same time, it can also issue an attachment under section 84 for these reasons believed by the court. Subsection 2 says, such order shall authorize the attachment of any property belonging to such person within the district in which it is made. So in that particular district only, where the jurisdiction of the court is there, so this attachment will be made, and it shall authorize the attachment of any property belonging to such person without such district when endorsed by the district magistrate within whose district such property is situated. So, and it will authorize attachment of a property belonging to such person without such district if possible. If it allowed, required, then endorsed by the district magistrate. So, if within district, no endorsement is required by any district magistrate, directly by the court's order, it can be attached. If the court orders to attachment to some other district, that also has to be done, but then it has to be done by endorsement of a district magistrate. So, we have learnt about this in the previous chapters where we talked about whenever an order, warrant, etc., goes to a different jurisdiction, that area, a magistrate, which is an executive magistrate or a judicial magistrate or a police officer, those people make an endorsement. That endorsement is again sent back, and this becomes a confirmatory evidence saying this person has received it and has a liability and accountability to act on it now. So that is why if it is out of district, within district, it's a jurisdiction of the court. They don't need any endorsement. But out of it, when it goes to the endorsement, for the district magistrate, it has to be done. And it is not a choice of a district magistrate to make or not make an endorsement. It has to be made, endorsement has to be made for sure. But endorsement is a only a technical step which has to be followed by the district magistrate. It's not an option or no option. Subsection 3 says if the property ordered to be attached is debt or other movable property, the attachment under this section shall be made number one, by seizure or by the appointment of a receiver or by an order in writing prohibiting the delivery of such property to the proclaimed person or to anyone on his behalf or by all or any two of such methods as the court thinks fit. So if the property which is attached is a debt for some reason, so it is some money has been considered in lieu of that particular property, movable or other movable property also, that attachment has to be made under this section. How it has to be made is by seizure. If it's a movable property, seize it. By appointment of a receiver might be there from court who is appointed, who will receive that movable property or the keys of the immovable property. That person could be a court officer or an advocate as well. And by an order in writing prohibiting the delivery of such property, so that property cannot be delivered to the proclaimed person or to anyone on his behalf. So nobody on his behalf or he himself cannot be delivered that property, movable, immovable. That order also has to be issued if the property is in debt. So it cannot be delivered to that though the persons on his behalf or himself, and by all or any two such methods as the court thinks fit. So by all of this or at least any two of it, the process has to be used in case of attachment of the property which is under debt. Subsection 4 says, if the property ordered to be attached is immovable, so that was purely for, previous one was or mostly for movable, primarily for movable. If the property ordered to be attached is immovable, the attachment under this section shall, in case of land paying revenue to the state government, be made through the collector of the district in which the land is situated, and in all other cases by taking possession. So if it is a land which is paying revenue to the state government, so which is in records of the revenue department, and the land which is being is being paying revenue to the state government. So if that is not paying the revenue is a different story. But if they are paying revenue to the state government, how do you pay the revenue to the state government? By paying various taxes on the land to the state government. So that we made through the collector of the district. So the person who will go and organize this attachment is through the collector of the district in which the land is situated. And you have seen in one of the previous sections that the for the sake of the seniority, the DM, ADM are considered at the same level, while SDMs are and various other executive magistrates are created for the subordination in various sub areas. So when we say the state the collector of the district has to through him it has to be done, which means it will be normally delegated to the SDOs in those areas who will ensure through other executive magistrate that this is effected through other officials also. So how it is done in that case, if the revenue paying land is there, by taking possession or by the appointment of a receiver or by an order in writing prohibiting the payment of rent on delivery of property to the proclaimed person or to anyone on his behalf. So even if it is rent generating property, the rent also cannot go to that particular person, it will go to the receiver. And by all or other any two of such methods as the court thinks fit. So the first one option is primarily for movable when it is under debt, or the second one is about immovable property. The first one, when it is movable, it is by seizure. So you can seize a movable property by appointment of a receiver who can receive that particular product or movable property, or by an order in writing prohibiting that property cannot be delivered to that person or his agents, and by any of the anyone by all or any two of such means. If it is immovable property which is paying a revenue to the state government, in that case, through the collector's office, it has to happen by taking possession of. So when you take a possession means you put a barbed wire or a small wall around that, and then you put a board there, black colored, and says under so and so order this property is attached. So you've taken a possession of that property, or by appointment of a receiver. So or you appoint a receiver who will then get this done, or by an order in writing prohibiting. So even there is an odd if there is a rent being generated on that land for some reason that cannot go to the person anymore or his anybody who is on his behalf, it will be not going there, and by all or any two of the such methods. So clearly given method for property attachment for movable or immovable. So it talks about these two things in section 3 and section 4. Sorry, subsection 3 and subsection 4. Subsection 5 says if the property ordered to be attached consists of a livestock or is of a perishable nature. So, for example, the property which has to be attached is a livestock. So, he has got a lot of cattle, cows, goats, such things. So, or of a perishable nature, fruits, vegetables, etc. The court may, if it thinks is expedient, order immediate sale thereof, and in such case, the proceeds of the sale shall abide the order of the court. So, very clear. If the things which are perishable or livestock, it has to be, if the court may think fit, maybe immediately sold off. And point number 6, the subsection 6 says the powers, duties, and liabilities of a receiver appointed under this section shall be same of those of a receiver appointed under Code of Civil Procedure. So whatever is under CPC, the procedure of appointing a court receiver is given, that is followed here. So this particular section talks about, as 84 talked about the proclamation, post proclamation or during proclamation, the property could also be attached for on suspicion, which court might believe that the person might dispose whole or part of his property and run away from that particular place. And for that, there is an authority to property attachment also given to the courts, because people are uh, you know definitely in a position to dispose of the properties in case they want to run away from the clutches of the law, because there is nothing to lose if they are moving out of the place with everything what is they have in that particular jurisdiction, and they sell it and run away. Or from all the other jurisdictions where in the same district or other district, if the person wants to wrap it off, the person would wrap it off to go into some other XYZ jurisdiction where he might be he might hide or conceal himself, or you might just sit back with that property converted into currency, and it's easier for him to conceal because there is no property record, etc., to disclose his identity and presence. So this grants the court and issued a proclamation who has done the proclamation that authority to attach the property of the proclaimed offender. Now, subsection 1 talks about the conditions of immediate attachment. So what are the conditions for immediate attachment? The court may order an immediate attachment if there is a reasonable ground to believe the person will run away, remove his property, and then the court allows the court to take a preemptive action in that case to preserve the individual's asset for any future legal proceedings, or maybe to control his presence. So the necessity of the court to record reasons for the attachment ensures that the accountability and transparency in its decision-making process. So if there is a reason which court has to give, they have to give in writing, and it has to be on the records of the same matter. Now, subsection 3 talks about attachment of movable property by seizure, by appointment of a receiver who can manage the property during the attachment period. So that person will then take care of the property, or prohibitory orders where they can prohibit any transfer of the delivery of the property to proclaimed offender and their representatives. So this flexibility method allows the court to adapt the nature of the property involved. So the seizure can happen that way. So attachment of an immovable property, if that happens, in that case, there is a prohibition of even for the rent, which could be taken out from that property, and that has to be not given to the proclaimed offender of the person, and the property has to be taken care by a receiver or possession by the collector, the district collector's office. Subsection 5 talks about the immediate sale of a specific properties. For example, the cattle's livestock, etc. If the court believes the livestock have to be sold, in that case, an immediate sale would be effected, and the proceeds from such sale will remain subject to the court's determination, which means the final disposition of the assets. The provision is crucial in the sense of preventing any loss of value in the property that could deteriorate or become less valuable over time. So this is, in a way, court is not only by selling, uh, you know, uh, taking care of that property, by also ensuring that it is not become less valuable over time, it does not lose its value, which is the case possible for perishable goods and the livestock. Now, subsection 6 talks about the powers and duties of the receiver, where the section clearly says that the receiver appointed to manage the attached property will have the same power, duty, liability that of a CPC. What it does is it connects to the CPC that particular part of the CPC which talks about the power, duty, and liability of a receiver, and it is avoiding defining the same thing under the CRPC or BNSS, which is already defined under CPC. It is just making a reference to that to ensure that the alignment on the established process already defined happens, and there is a consistency whether it's a matter of a criminal case or a civil matter. The receiver is receiver, and if it has the receiver has got the same power, duty, and liabilities, etc. So the receiver normally manages on behalf of court, or they also manage transfer the things on while receiving and passing out to the court. So what is the practical implications? What is coming with Section 85 is attachment of property of the proclaimed offender is it prevents the evasion of justice. So there might be an evasion of justice which can happen where person can evade by running away from the main scene by disposing of all his properties and running away with the assets converted to cash, or streamlining action against the proclaimed offender. This also puts a activity further, which will deter the proclaimed offender, and it's a tool for law enforcement also to manage the asset of individual who are avoiding arrest, enhancing the efficiency of legal process and against that individual. And it also is something in sum total is a protecting the public interest also, because such people uh, who are running away, if they are holding a perishable goods also, that is also taken care in that case. And in general, the public also see a very strong claw of the law, which is not letting the person proclaimed running away with his property. So while it is also saving the proclaimed offender his property, preserving it, not letting it lose the value, on the other hand, it is also establishing a sound uh, presence of judicial power and the law enforcement in the minds of the in public in general also, who see the proclaimed offender as an offender. Section 86. Let's move to section 86, which is an identification of and attachment of property of proclaimed person. Now, the court may, on the written request from the police officer not below the rank of superintendent of police or commissioner of police, so which is in the commissionerate area, it's a DCP or a CP or a joint CP of a police, initiate the process of requesting assistance from a court or an authority in the contracting state for identification attachment and forfeiture of property belonging to proclaimed person in accordance with the procedure provided in chapter 7. So this particular is subject is talking about the contracting state. So in the contracting state, in a state where the properties are there, in that state, with the on the written request from the police officer not below the superintendent of police or commissioner of police, initiate the process of requesting assistance from a court or an authority in the contracting state for identification, attachment, and forfeiture of property. Now, what is this talking about? This section talks about authority to request assistance. So this is where grants the court the authority to act on a written request from a police officer holding a rank of at least so and so, which is mentioned, which is SP or a commissioner of police or a DCP or a CP or a joint CP. This provision facilitates cooperation between law enforcement and the judicial system in dealing with the assets of individual who has been declared proclaimed offenders. So, if the letter is requested from such and such people from a police officer, in that case, at that rank, if it is received, the court has an authority to act on it. So the request from a police officer must focus on identifying, attaching, and ultimately forfeiting the property of the proclaimed person. This ensures that not only is the individual sought for arrest, but that their assets can be managed and potentially forfeited upon conviction or during legal proceedings, which is a mixed scenario. In the scenario where the court which has make a person proclaimed might not have any reason, opportunity to make his property attached. But in that case, during investigation, if these police officers might have come across so and so property, then they will reach out to the court in that jurisdiction for an assistance, and they can. So we were talking about in the previous section, sending to the judicial magistrate, to the executive magistrate for the proclamation activity for the revenue related affair. Here, the police can come to that particular jurisdiction with that proclamation details, and they can ask for a uh, to the court for on a written request for attachment of the property. Maybe it is discovered later at point of time during investigation. So this action takes for attachment and forfeiture must follow the procedure outlined in chapter 7 of the BNSS. This adherence to the established legal framework ensures that all actions are conducted lawfully and in due process. So this is under chapter 7, which is done. Just give me a moment, I'll just read. Okay. So by the time this is also an international cooperation, because if you see the word which is used is a contracting state. So we have studied about the contracting state earlier as well, where the contracting state where we have a mutual agreement to assist each other. We have read about this in a previous section also. So those states are the contracting states. So that is also which is something taken care in this section, which highlights that the court may seek assistance from courts or authorities from other contracting states also. So, which implies an international cooperation also. So, everything, whatever is given in chapter number 7, depending upon that compliance of the process, this can happen, which is the process of to compel the production of things, and that process is given how the things are produced on instruction of the court. What is the practical implication? It makes the accountability of proclaimed offender by enabling attachment property belonging to such people, and they cannot shield their asset from judicial process while evading arrest. This also gives a benefit where a police can seek an arrest for a proclaimed offender, and including that, they can also seek in that state the attachment of that property. And it strengthens the legal authority and enhance the local enforcement capability globally as well, in all the contracting states as well. So it provides a procedural framework for the courts to act upon request from senior police officers to identify, attach, and forfeit the property of the proclaimed offenders by establishing clear guidelines as per chapter 7, and allow the international cooperation also in this section This section enhances the ability of law enforcement and the judiciary to hold offenders accountable while protecting the integrity of the legal system across the seas as well. And the provisions support a proactive approach to address the crime and ensure that the individual cannot evade justice by hiding their asset. So if a bank account has to be attached, that will also happen in a contracting state with the this section only. Section 87, then we move to section 87, which talks about the claims and objection to attachment. Now, if there is attachment happening, there would be a claim to claim of objection as well. So if any claim is preferred to or objection made to the attachment or any property attached under section 85 within 6 months from the date of such attachment by any person other than the proclaimed person, on the ground that the claimant or objector has an interest in such property and such interest is not liable to be attached under section 85, the claim or objection shall be inquired into and may be allowed or disallowed in whole or in part, provided that any claim preferred or objection made within the period allowed by this subsection may, in event of the death of the claimant or objector, be continued by his legal representative. So it might be a situation where the property is attached. There might be people who may come back and raise an objection that they have an interest in the property. But this person who is coming for the interest of this property should be anybody else apart from the proclaimed offenders. That person proclaimed cannot come back and make such a claim under section 87. But what grounds on which they can make the claim is they have such interest in the property, and that is why it is if that is their interest in the property, and if that could be proved, then the property cannot be attached under section 85 against that proclaimed offender's name. So this claim has to be made within 6 months of this attachment. So there is a limitation period also given, and the court will go back to inquire in such claims or objections to check if this claimant or objector who is coming the picture is actually somebody who has really be able to prove his interest in the property. And if that is possible and that is understood, that is agreed by the court can uh, allow this application, and the person that particular attachment of the property will be released, and the property will be released to this claimant or objector. Or if the court doesn't find it's correct, the court may disallow it wholly or partially. So wholly it may be happen the house which was supposed to be that particular claimant, that particular proclaimed offender was actually grabbed by him, and that was not known to people. When the property was attached, later point of time, there was already some issues were between that particular actual owner and this proclaimed offender, and the whole of the house is something which was belonging to that particular claimant or the objector who comes back and said, okay, this is not the title of the house is not with him, it's with me. And in that case, you cannot attach this property in the name of that proclaimed offender. So it will be fully going back to in hands of that person who is making this claim or objecting to this particular attachment. And in that court case, if the court is satisfied, it may allow the application, which is the property will be released to the person who's claiming it to be and objecting to that particular attachment. Or it might happen that a property which is attached, which was actually something which was a property jointly purchased by two or three people, and they have their fair share of investment of buying that property, and they can claim that and get a partial release of that particular property of that value, or probably whatever the court further takes a decision, maybe uh, in that sake, the relief will be given to the other party partially or wholly. Subsection 2 says claims or objections under subsection 1 may be preferred or made in the court by which the order of attachment is issued. So it has to go back to the same court where the uh, attachment order is issued. Or if the claim or objection is in respect of property attached under an order endorsed under subsection 2 of section 85. So if it was endorsed under subsection 2 of 85 in the court of the chief judicial magistrate of the district in which the attachment is made. So there are two reasons two areas we have seen. One where in the same district, this particular attachment order has to be made, and in that case, they does not need an endorsement from any district magistrate. While if it is has to be executed in some other district out of the jurisdiction of this court, an endorsement has to be made. So that is what it is mentioning. So the claim objection, either number one, if in the same district where the court has issued it, the property is also in the same district, in that case, you go ahead and you can make a claim in the same court which has given that original order of attachment. If the property is lying outside in the jurisdiction of that court, and the court had got an endorsement from the district collector from the other district and or other state district, in that case, in those areas, the court of the CJM of the district in which the attachment is made, there the claim could be made. So you have to go to the chief judicial magistrate of that district where the district collector has given an endorsement. Subsection 3 says every such claim or objection shall be inquired into by the court in which it is preferred or made, provided that if it preferred or made in the court of a CJM, he may make it over for disposal to any magistrate subordinate to him. So if it goes to the court where it was originally it was ordered in the same jurisdiction, the property is also there, such claim or objection shall be inquired into the court which is the same court. And if it is going, the application is going to the CJM, it will uh, either dispose it himself, herself, or it might be passing on to a relevant magistrate subordinate to him. It is just a simple procedural step which is mentioned here, where who will primarily we talk about do it in the other jurisdiction when it is referred to the CJM in the other district. Subsection 4 talks about any person whose claim or objection has been disallowed in whole or in part by an order under subsection 1 may within a period of 1 year from the date of such order, such impugn order as they say, institute a suit to establish the right which he claims in respect of the property in dispute, but subject to the result of such suit, if any, the order shall be conclusive. So within a period of 1 year from the date of such order, they can institute a suit to establish their right, which is claimed in respect to the property in the dispute, but whatever is the final resolution is the conclusive one. There cannot be any further. So this section 87 talks about the right to make claims and objections, which is subsection 1 talks about that there is a right which is given to make such a claim and objection. So there is a window given so that somebody who is not part of this particular, somebody who is not the proclaimed offender and who is actually party who has an interest to the property is not illegally the property is taken away from them. So this provide a mechanism for these individuals other than the proclaimed offender only to challenge this attachment of property and under section 85. So this particularly is important for ensuring that the right of the third parties are not taken away who have the interest in the property, genuine interest in the property, and which has to be recognized and protected. So this is a mechanism given in those scenarios. Now, but there is a time limit given, which is a time of 6 months from the date of attachment, and the limited time frame ensure that the timely resolution of the dispute happens and without and it help prevent the indefinite withholding of the property. So property is not withholded immediately because then it has to be time bound. And the grounds for the claim could be the claimant or the objector will come back and demonstrate. They have to demonstrate, get it verified that they have a legitimate interest in that property, and their interest is not subjected to attached under Section 85 thus. So their interest cannot be subjected to the Section 85 interest. Now, what is the jurisdiction and the jurisdiction and the court of the claim is discussed in subsection 2. It says what is the jurisdiction and which courts can receive such claims. So claims or objection can be submitted to the court primarily which is issuing the attachment order, ensuring the continuity and cooperation in the legal process in the same jurisdiction. So you reach to the same court. While in case where the property is from the other ordered endorsed, so the claim has to be made in the court of the CJM in that district where the attachment is executed. So the provision ensure clarity on all the two options, because 85 gives you two options: district, other district, endorsement, non-endorsement. So providing accessible forum for interested party in both the places. Now, why the jurisdiction in the second place is given to the CJM in that court is a very important question which arises here. It is a very simple uh, uh, understanding based on previous chapters what we have already studied is the court. Sometimes they even you have seen in some other sections also that the courts might pass on a request to the other courts in some cases to uh, run those particular inquiries, etc. In that case where it does not have a jurisdiction. And the sole purpose which was mentioned in those sections around that is they are well equipped to understand the local geography, they understand the little local laws, and understand the have the means to inquiry into the local areas. So if the same court which has no jurisdiction, actual jurisdiction in that district, if they would have made a law where they would have given the power to only one court which has actually started this particular process of proclamation and attachment, which has requested the other district, what would have happened is they could have be paralyzed because they would have no particular uh, officers, means, etc. to validate, verify, and it will be inconvenient also to people connected to the matter to come travel to all that way to the district where they have to come and uh, you know uh, face the trial together. In that case, and that is why it is from the judicial inquiry and from the trial perspective, the the process is handed over to the CJM or the subordinate courts of that CJM in that particular jurisdiction to be made. Subsection 3 talks about inquiry into claims and objection. So, the court that receives the claim or objection is required to conduct an inquiry into the merits of the case. That is the purpose. And this allows for a thorough examination of the claim being made regarding the attachment of the property. And the local court in both the areas would check the records, bring the records, etc., from the local departments of the land and the revenue to present it to them quickly, swiftly, and in continuation to deliver the justice. In claim or objection which is made to the CJM, the magistrate has the discretion to delegate it to a subordinate magistrate, which we know already, and that is only just for the delegation of work, promoting efficiency, etc. So, which is something which is applied to a CJM lands to some other subordinate magistrate's court. Then subsection 4 talks about the right to institute a suit. So, should the court rule against the claimant or objection in which whole or in part? So, whatever objection has been done in whole or a part. So, whole application was rejected or partially the the particular application was accepted. They may initiate a civil suit then to assert their right relating to the property within 1 year from the ruling date. So, within 1 year, they can file a civil suit against that ruling, but the order which the court regarding the claims will remain the conclusive. So once the order comes, so remain conclusive unless it might be overturned as the outcome of the suit, the previous order, or it might be continuing with the same particular order. So this provision offers a pathway for individual to seek further legal resolution beyond the summary process provided in this section. So whatever legal resolution provided in the first part, which is the very first court which has initiated the proclamation, or the court which has which is in the jurisdiction of the other district where the attachment of the property has happened. In all the cases, the first level is the courts, these two courts, while the person within 1 year can go back and file a civil suit also against any such impugned order where they want a relief against either it was rejected fully or partially, and that second chance is provided in a detailed execution of trial through a civil court, because these matters which are normally run in such courts are run normally in a summary process. So, in a proper detailed way, if a matter has to run, it can run within a year. It could be initiated as a suit in a civil court, and that in that case, whatever judgment comes at the end with that civil court, that becomes the final and conclusive judgment. So, this particular section protects the right of the third parties which are getting you know, pained by this particular attachment of the property of the proclaimed offenders, understanding it is their property, but it might not have, no, not be, and there are interests of the third parties onto that, and it facilitates the legal recourse by a very structured mean, where to appeal, how many times to appeal, etc., etc., and it gives a clear judicial oversight because in both the conditions, both the areas, the judiciary is available to oversee and ensure the decisions are made as per the due process. And but it is a time bound process that within 6 months you have to, in the first part you have to go, and within 6 months you have to make a claim, and in the second part within 1 year you have to make a claim, and then the judicial inquiry is considered the final outcome in both the cases, and whatever comes in the second part of the relief which is provided through the civil suit, in the civil suit pathway gives the final relief to that particular person, whether the whatever judgment is coming there. And it might also happen that instead of relief, the particular uh, objection or that particular uh, claim could be rejected. And once it is done, that is the final concluding uh, result, judgment. So to pursue a civil suit after a ruling on the claim, preserve their ability to contend the court's decision. So thereby providing a safeguard against potential error and ensuring justice is accessible. So to any error is also ruled out with that. So this is a very strong framework given in case of the proclaimed offender and their properties. Now let's talk about section 88, which is release, sale, and restoration of the attached property. So when the release, sale, and restoration of the attached property, how it has to done. So if the proclaimed person appears within the time specified in the proclamation, the court shall make an order releasing the property from the attachment. So if the proclaimed person is appearing within the time specified in the proclamation, the court shall make an order releasing the property from the attachment. Because we know that the proclamation and the attachment of property, both the issues can, both could be issued together, and then within that 6 months of time, the property is not disposed of. So, within the time frame, if the court is also drawing some timeline for the person to appear, in that case, if the person is appearing, in that case also, the court may order on satisfaction the release of the property if they believe the person has actually not evaded the law, but there were some sound reasons why, probably for example, in one of the matters recently, uh, there was a person who had a uh, check bounce case which was brought against him in one of the courts in Maharashtra. Now, it so happened that by the time the person had moved to some other district, in that case, the check amount being very huge, there on instructions of the court, a proclamation was also called upon that person, that this person has duped the people with crores of rupees through a check which has bounced. But what had happened was, in that due process, the person had actually had a different understanding of the situation, and he had opened a different bank account, and he had again issued a check, and he had sent it to the parties to their addresses, which was not delivered for some reason. It was delivered to some wrong address. By the time these people made him a proclaimed offender, and the notices were issued, which was missed by him. It was not published in the newspaper, it was only published in the locality, and it was published in the court. And as he moved to the different district, he had no access to the place, nobody informed him. And then suddenly a attachment of property order was availed against him. In that case, the person made himself presented in front of the court, and they came back. The person comes back, and then he provide presented all the valid reasons to the satisfaction of the court, and this was attachment of the property order uh, was reverted, and the property was released to that particular person. So there are situations, genuine situations also, where the person who is proclaimed as an offender is not actually really an offender. What is the purpose of the law to do is to ensure that by the same scale, just depending upon the offense, there should be some rules and process framed to ensure that the person cannot run away from the clutches of the law, and if he or she tries to do so, and if possible, their properties, etc., could be confiscated to ensure the justice is prevailed. In this case, the court might have gone ahead and uh, effected the sale of the property to fulfill the amounts to be paid to the petitioners. So, in that case, in this case also, and many such cases, the person who might be a proclaimed offender, which is a procedural effect from the court. It is not that every proclaimed offender is a terrorist or a criminal or some kind of a repeated offender. So that is why these particular provisions give relief in those cases also where it is not really the case. It was the discretion of the court through either by their own act or by uh, such instruction, such request made by the parties. The court might have believed that, and as a process, general process of preserving the property or safeguarding the rights of the plaintiffs in those cases, they might go back and go with those processes. But at any point of time before that, or even if the sale of the property has happened, in those cases, you'll come to know shortly, the courts have right to reinstate the rights of the other person also, who was considered proclaimed offender. Will not said wrongly by the court, because it's a procedural thing and the courts have a procedural framework under which they do it, but it's because it was proved that way in the court. So in those cases, the within the time specified, the person can get an order releasing his property from the attachment. In fact, he could be getting an order also to release his name from a proclaimed offender as well. So if the proclaimed offend person, if the proclaimed person does not appear within the time specified in the proclamation, then the property under the attachment shall be at the disposal of the state government, but it is shall not be sold until the expiration of 6 months, what we said, so that any person who can want to make a claim against it can do it. And until any claim preferred for objection made under Section 87 has been disposed of. So it is within 6 months, or within 6 months, if somebody has made a claim and an inquiry is going on, etc., then also it cannot be disposed of. And if a person gets a impugn order and the person goes to a civil court also within that point of time quickly, the property is then preserved until that point of time, which is quite logical. It has to happen that way. And under that section, so unless it is subjected to speedy and natural decay, or the court considers that the sale would be, which is the case of livestock, we talked about it. So until and unless it's a case where a natural speedy decay can happen, the property is preserved in the full spirit and the shape and structure how it is when it was attached. In either of which cases, the court may cause it to be sold whenever it thinks fit. So whenever it thinks, court may sell it at any point of time, whether it's any kind of property. Subsection 3 says, if within 2 years from the date of the attachment, so within 2 years from the date of attachment, any person whose property is or has been at the disposal of the state government under subsection 2 appears voluntarily or is apprehended and brought before the court by whose order the property was attached, or the court to which such court is subordinate, and proves to the satisfaction of such court that he did not abscond or conceal himself for the purpose of avoiding execution of the warrant, and that he had no such notice of the proclamation as to enable him to attend within the time specified. So therein such property, or if the same has been sold, the net proceeds of the sale, or it parts only thereof has been sold, the net proceeds of the sale and the residue of the property shall, after satisfying therefrom the courts incurred in the consequence of the attachment, be delivered to him. So within 2 years, the time is given to the person who is proclaimed offender also, whose property maybe at that point of time has been sold. It's said that the property might be preserved when until some kind of first 6 months, then until the first stage of challenge is made against any claim, or against the within a year of time a second claim is made as through a civil suit. So in those cases, the property might be preserved for more than 2 years also, or it might be a case where the court might not immediately go for a sale of a property for some reason, maybe advised by the district collector, etc., and the it might be marked for sale for some other year as well. So all those areas cases, who receives the money? The money whichever is coming out of the after the sale of the property, partially or fully. So maybe the person might have 5 properties, 4 had been sold or 2 had been sold. So in that way, so if the property is sold, and the fully or partially, where the money goes, it goes into the coffers of the revenue department, which is headed by the collector. So the money goes to the revenue department and it is integrated into the accounts of the state government, which means a portion of that money is part of the state government's account already in the revenue department. So in case after 2 years, sorry, within 2 years of that particular time period when from the date of attachment. So whenever the attachment was completed, and that person, if who has been present voluntarily, he himself appears to the court in the case which I said, and mentions to the court, "Hey, I'm not proclaimed offender, and I did not had any information. I'm not somebody who will not abide by the law, and this is what the scenario I've been invisible and or absent, or the person is brought, for example, for some reason the police brings that person saying he's a proclaimed offender is found, and we are presenting him to the court for the further orders around this. So in all those cases, if he is able to satisfy, now by that point of time, quite a chances 50-50 that the property might have been already disposed, which is sold off by the state government. In that case, the property, if it is sold fully, then whatever money was recovered, that money, uh, excluding a standard rate, a cost which is charged for the price of conducting that particular auction. So that price is deducted, and then remaining part is transferred from the state account, revenue department's account to that person. Or if a partially that property is disposed of, whatever the money was recovered, whatever the the proceeds which has come from the sale of that particular partial part of the property, that particular subtracting the cost of whatever the cost which was incurred in the consequence of the sale of the property by the state government, plus whatever remaining property is released back to that particular person who is not a proclaimed offender as satisfaction to the court at that point of time. So this is a detailed section talking about the release of attached property in case it has to go back to the proclaimed offender. Previous one was releasing the property and giving it back to the person who is making a claim that this is not proclaimed offender's property. This is my property, and he claims and release the property is released back to. There is a more than 100% chance in the previous section of the receiving the property until and unless it is not a livestock or perishable item to go in the same shape, size, design back to the person who is making a claim if he is able to satisfy. While in section 88, it is quite a possible that this particular sales of the properties already have happened, and if not happened fully or partially, in that case, the property is restored to the person, it is released back to the person, or in that case, if it is sold, it is going back to the person, the whatever the money has been received from the proceed of the sale, subtracting the cost around that. There is a standard procedural cost which is attached by the tables given by the various government GRs. So subsection 1 talks about the release of the attached property. It says it can be released. That is what it is confirming in section 1. So subsection 2 talks about the disposition of property in the proclaimed person fails to appear. In case if the person is failing, then what happens? It is waiting for 6 months, then it is waiting for resolution of claim and other objections by the people for that particular resolution period, whatever happens in the various courts. And then exception to the sale delays, the property may be sold earlier also if it is subjected to quick decay. So if it were livestock, etc., it might have been sold before 6 months also. So that in that case, the claimant or the person making an objection receives the money, or the person who is a proclaimed offender might receive it. Now, subsection 3 talks about the restoration of the property, that within 2 years from the date of attachment to the satisfaction of the court, that the person has not absconded or they've concealed to avoid arrest if that is proved beyond any doubt, and that they did not receive proper notice around that could be proved, that in all these cases it enables them to, if they respond within that time period, then they can receive the proceeds of the sale subtracted the cost, or they can receive the proceeds of the sale plus whatever property is remaining unsold. So what is the very, very important part of this is, as we talked in the very first day, BNSS or any such law, it takes care of the accused, their right as well. and it protects the right of the individual who was also considered an proclaimed offender under certain sections, and it gives a judicial efficiency by taking a U-turn also if it is required, and gracefully help the person who was considered wrongfully by the, not by the court, but by the situations and the evidences and the facts presented in the court, and a rightful judgment has been taken under that those light of circumstances, while the facilitating a prompt justice in case if the person is able to prove otherwise. This is section 88. Now let's talk about section 89, which is appeal from order rejecting application for restoration of attached property. Now it is not always possible or happening that the person comes back and makes an appeal for the request for an application for restoration of the attached property to him or her. In that case, it might also get rejected. In that case, the section 89 is talking about that scenario, about appeal from order rejecting applications for restoration of the attached property. Now, any person referred to in subsection 3 of section 88. So who is mentioned in subsection 3 of section 88? Let's read subsection 3 of. So within 2 years, the person who has come and who is able to satisfy the court. So it says any person referred to in subsection 3 of section 88 who is aggrieved by any refusal to deliver property or the proceeds of the sale thereof may appeal to the court to which appeals ordinarily lie from the sentences of the first mentioned code. So whatever this court is subordinate to, the appeal will go to that court. So this says there is a right of appeal also. It doesn't say that the person who, and it goes to the court which has attached the property or declared him a proclaimed offender, might satisfy him. He might get a impugn order from there which might be against his application and wishes, and the property or the proceeds of the sale is not restored to him. In that case, still the person also has a right of appeal. So this right to appeal is established via section 89. So who are affected by the decision, the proclaimed offender, they get a right to appeal, and which is a very very fair right to bring an accountability in the whole of the judicial process. If you see, the similar thing has been given to the person who's making a claim also in the sections where he can make a second application as a civil suit also within 1 year of within 1 year of time. So in that case, the similar kind second option is for appeal is also given to the person who is claiming under section 88, and this right is given under section 89. So this section clearly applies to the individual who are defined in subsection 3 of section 88, which is the person who has been declared an proclaimed offender and who has come back and is trying to come back and satisfy the court that he has not absconded or evaded. It was a genuine, he was genuinely interested to abide by the laws, but he could not for some reason. And it pertains to basically solutions where a person whose property has been attached can demonstrate that did not abscond and they have not run away. And for such people who have made an application and failed in that particular original court where this proclamation or the attachment property was ordered, so such individual, if dissatisfied, can obtain order through an appeal also, and it will be directed to the court which is typically handles appeals from the decision of the original court. So that court which has issued the order of attachment, wherever the appeal lies from that court, the appeal has to be presented in that particular court, which is a normal and established process of pathway of redressal in any case. So purpose is ensuring an access to justice in spite of first denial in the order, and a judicial oversight is also overruled by the appellant court. So if there might be a judicial oversight also which has happened, which is not something which is new, there is a procedure established because it can happen. And if that is the reason, a judicial oversight is also attached to the process where there is an effort to preserve the right of the person who is not actually somebody who is a proclaimed offender, but is is pronounced a proclaimed offender because of some confusion, deficiencies, or some genuine reasons. So this protects the protection of the property right of the person who is an accused also in this case. It promotes a fairness in the legal procedure also, and it encourages the judicial vigilance also through the appeal. So very powerful section, which is empowering the section 88 for the person who is making such a request of reclaiming of his property or the proceeds in the sale, whatever has happened of his properties. Section 90 then talks about issue of warrant in lieu of or in addition to summons. Now, a court may, in any case in which it is empowered by this Sanghita, so the court, in any case in which it is empowered by the Sanghita to issue a summon for the appearance of any person, issue, after recording its reason in writing, a warrant for his arrest. So a person who is first given a summon and who is empowered by this Sanghita to issue a summon for the appearance of any person. So if the summon has gone, summon is nothing but a mild an order, a request for the person, informing him that uh, you are expected by the court to be present in so and so date in so and so hearing for so and so reason. If the court believes in any case, and after recording its reason in writing, can issue a warrant. So what is the difference? In summon, the person walks by his own. When the summon is issued and the person is issued summon, the person is expected to walk by his own to the court and present himself. But the court, in any case, if they believe so, which we'll discuss now, can also issue a warrant. When the warrant is issued, some law enforcement agencies would come, or somebody who is empowered to or trusted by the court to execute that warrant will go back and make the person present through his efforts in the court, through the physical efforts. So subsection A says, if either before the issue of such summon or after the issue of the same, but before the time fixed for the appearance. So after, either before the issue of the summon only, if there is a belief, or after the issue of the same also, but before the date when the person is summoned for, the court sees the reason or believes that the person will abscond or will not obey the summon in that case. So before even issuing the summon, directly a warrant could be issued, or if the issue of the same has happened, but the court has a doubt and the time is not right, not has come until the person will come and would have presented himself. So in these two time frames, the court can, if has a belief the person will abscond or will not obey the summon, can issue a warrant instead or additionally to ensure the person's presence in the court. B says, if at such time he fails to appear and the summons is proved to have been duly served in the time to admit of his appearing in accordance therewith, and no reasonable excuse is offered for such failure. So these were the first two conditions were given, that this can be done either before the summons are done, directly warrant, or the summons are already issued and the court, before the appearance time, believes that the warrant is necessary. The warrant could be necessary and the court will be believes that person will abscond and will not respect the summon, or even at such time when the summon is issued, the summon was received properly, duly served, it was considered served in the court records, and then the person has not appeared, and then in that case again also a warrant could be issued. So this is an authority to issue a warrant over or uh, either to the warrant, which is section 90 talks about. So it grants the court authority to issue warrant for the arrest of individuals in conjunction with or instead of summons. Either of the cases, either together with summon or instead of summon, they can happen. So what are the three conditions? One is, instead of summon, when the court at a very first start only believes that the person, if summon would not come or would abscond, they could issue a warrant instead of summon at the very first place, or in conjunction with the summon when they've already sent a summon, but later point of time before the fixed time of appearance, the court believes he will not come. Then a warrant could be issued, or in conjunction where the summon has been issued, duly served, the received, it is received, the notification of completion of serving of that particular summon is also received, and the person still has not appeared himself, then also a warrant could be issued. So in those cases, there are two options of in conjunction with summon and one option where instead of summon, the warrant could be issued. And this section says that the subsection 1 says, the subsection A says, that what is the condition of issue of a warrant, and in those cases what we just discussed, and the written reason is required. So ordinarily the summons where it has to be issued, and instead of that, if a warrant has to be issued, which is an exceptional route if taken, and which is a harsher route. So law always promotes the very first instance, whatever is first of all possible has to be. So as they say in the courts also, the Supreme Court has been also calling up that jail is an exception, bail is a condition. So very same way in any other, in all the situations, the mildest of the option to, by considering that the person would comply with, the summon has to be issued. But if a harsher route has to be taken, say for example, before the summon issued or just after issuing the summon, then in writing the condition has to be clearly given. It becomes far more important for the court to write such reasons, or believing on such reports or instructions or such kind of request or such kind of facts revealed to them or their own particular beliefs. They have to write it clearly, which is justifiable to issue a warrant. But it becomes easier to write such a justification in case the summon was duly served and then the person has not appeared. So, but in either of the reason, the written reason has to be clearly given by the court. So it gives a efficiency in the legal proceeding, because every time when a hearing is scheduled for some reason, it is very efficient if the people are available on those dates and time. Until and unless they don't do so, either it might not be giving the complete justice by giving a rounded judgment by hearing to both the parties, or it might not be efficient in terms of the timelines which might be extending beyond because of the absence of the people. This is again a deterrence against the evasion. So this becomes a deterrent factor that the person is believed to be handled with iron hand has to be handled with iron hand in the execution of the justice. And the judicial responsibility is shown here. So it is not only the executor's responsibility that they go and arrest, they make their steps to ensure that any cognizable offense, non-bailable offense is not happening under or before they arise, etc., etc. It is also a judicial responsibility, accountability by the judges, which they can execute using such kind of sections where they can ensure through the help of the executors that the particular trial is running on time and with the right people's presence as it has to be made. So this is a very strong section, section 90, which reinforces the court's power to bring in efficiency and deterrence of any such kind of evasion in case of the court believes so and is made to believe so. When we say when court believes so is something which is called a suo motu cognizance, or it might be made to believe through various affidavits, appeals, applications, requests, fact presentation, etc. Section 91. Let's move to section 91, which is power to take bond or bail bond for appearance. So when any person for whose appearance or arrest the officer presiding in any court is empowered to issue a summon or warrant is present in such court. So for this person whom we spoke about in section 89, sorry, section 90. So any person for whose appearance or arrest, so either a summon or a warrant. So his appearance or arrest is nothing but summon or warrant. The officer presiding in any court is empowered to issue a summon or warrant, is present in such court. Such officer may require such person to execute a bond or bail bond for his appearance in such court or any other court to which the case may be transferred for trial. So this is an authority to require bond on top of the powers which is given in section 90. So this is the person for whose appearance either a summon or an arrest warrant is issued by that particular judicial officer. And if that person is present in front of his eyes for that presiding officer, the officer may require such person to execute a bail bond. So it empowers the presiding officer, the magistrate, judge, etc., whomsoever, to request an individual present in the court for whom they have powers to issue summon or warrant, or they have done so already, for whom a summon warrant has been issued for appearance or arrest, execute a bond or bail bond. That provision is integral to the judicial process to make that person accountable to come next time in the court, providing a flexible means also for the person that he is not sent in a judicial custody, his freedom is still intact, and the court is also ensuring his presence. That accused individual remain accountable during the legal proceedings to be present in front of the court. It could be a bail bond or a bail bond. So a bond is a legal commitment which the person might make has to make to appear before the court as required, and it represents a formal assurance that the individual will return for the future court appearance, which is a bond he has to write, or a bail bond, where typically a financial commitment is made for that person and to meet the secure that they are released from the custody while awaiting trial. So if through warrant the person has been brought in, the person either has to sign a bond or bail bond so that they are coming back, or it might also possible that before even issuing a summon next time, if the person is visiting by summon also in the court, the presiding officer can still ask for a bond or a bail bond if they have a suspicion. Next time I might have to issue a warrant to bring that person, and he will not again next time respect the summon. Applicability is when present in the court. Of course, the person has to be present in this scenario to be in the court. So this section applies specifically when the individuals is physically present in the court, and the requirement to execute and bond in this context facilitates the immediate legal obligation to be created without unnecessary delay and straightforward. It reinforces the court's control over the proceedings. This bond is not only applicable for the current court, but for the court which is where the case might be transferred for trial also later. So this ensures a continuity for the legal obligation binding the court. So even if the transfer of the case happens, this is something which is important, which is said by the last line, which says this of the section, such officer may require such person to execute a bond or bail bond for his appearance in such court or any other court to which the case may be transferred for trial. So if the case is being transferred to the other trial also, the same bail bond will be applicable to the other court also. So this gives a very strong judicial efficiency on top of the warrant and the summon, where through bond, which is a promise, or a bail bond, which is a financial or surety-based commitment, the court is ensuring the person is coming to the proceedings as and when required, and also in a way helping the person by establishing his right of freedom and very responsibly applying the legal procedure, which is actually in benefit of the person instead of a loss to the person. Otherwise, the other option is to send him to the judicial custody, which will be curbing his freedom. Let's talk about section 92 now. Arrest on breach of bond or bail bond for appearance. Now, the person was sent a summon, the person was sent a warrant, the person was in the court before even sending next summon, or the person is in the court after receiving a summon, or a person is in the court after sending a summon and then again sending a warrant, or a person is there in the court where in the first place warrant was issued, or there is a condition where the person is in the court because the summon failed and he was brought to the court through a warrant. So in either of the case, and the person is when in the court, the section 91 allows the judicial officer in that particular court that in his presence he signs a bond or makes a bail bond. So what happens in spite of that, if the person who is arrested in all those conditions which I said, what conditions I said? The conditions where the person has appeared with a summon before the next summon is issued to the person. Second condition, where the person is issued a summon and then a warrant was issued simultaneously, and the person is actually in the court after issue of both the summon and the warrant, or the summon was not at all issued. The person was issued against the person, a warrant was issued and the person was brought to the court, or in a situation where someone was executed only and it failed, and the next time the person was brought in the court with the warrant. So in either of the scenarios, the person has come, the court has wanted him to sign a bond or a bail bond, and in that case, again the next time the person breached this bail, this bond or the bail bond for appearance. This bail and bail bond, which was mentioned in section 91, is breached by the person. So when any person who is bound by any bond or bail bond taken under the Sanhita, now it is applicable in both the courts. the main court where this has happened or the second court where the case is transferred. So in all the cases, when a person who is bound by any bond or bail bond takes under his this taken under this Sanhita to appear before a court, which is section 91, does not appear. The officer presiding in such court may issue a warrant directing that such person to be arrested and produced before him. So the court can again issue a warrant against that person. So this is a breach of bond obligation. So this is a breach of bond obligation of the person against whom the matter is running and the person against the person who has signed the bond or the bail bond for appearance. This is an obligation which is breached. So breach of bond obligation which has happened, which is mentioned in section 92, that they have executed a bond or a bail bond and they are non-compliant. Now, what is the authority? Authority is to the presiding officer. So the authority is given to the presiding officer. So it transfers from the main court to the transferred court if the case is transferred. So this is if the person is in the original court which has taken the bond, it is the presiding officer of that court. If the bond was taken in the first court and the person moves to the second court when the trial was transferred, it is the presiding officer of the second court who will take that action. So if an individual who is bound and appear in either of these courts fails to do so what he has promised, the presiding officer in either of the courts, a magistrate or a judge, has the authority to issue a warrant for their arrest. This action is intended to bring the individual back to court to face the charges or proceeding against him. Now, what is the importance of this judicial control is the presiding officer has a directive to issue a warrant demonstrating that the court has a control over the proceedings, and this control can be established even if they violated or breached this obligation. And this is a requirement of the individual to ensure that comply with the legal obligation created by bond. The process of issue of the warrant is given here, which is the issue of the arrest warrant allows the law enforcement now to take the immediate action against the individual who has breached this bond. And this ensures that individual cannot evade justice by simply failing to appear as required in spite of signing a bond or making a bail bond. And please understand, this is in combination of whatever sections you have studied earlier with me. For example, it might happen the person has changed his jurisdiction of stay also. In that case, this warrant will be issued to the other state police senior officials who will make a uh, uh, signature on top of that particular warrant which is sent there. So by endorsing that, they will make an action. They will return the person back to the main court. Or it might happen a police officer from this jurisdiction might go to the other jurisdiction, and the person will go and make an arrest either by himself. But while making an arrest with help of the local police, he needs an endorsement from the police officer of the rank of at least of the rank of a senior police officer, a DSP or SP or a commissioner of police. And also he has to provide a notice in the police station while returning also. And then there are processes he has to follow in the court from which jurisdiction the person is being brought in, and the person has an opportunity still to uh, request for a bail bond from that local court also. So it is not simply when you read one section, it is application of all the sections we have read earlier. So the applicability happens multifaceted in all the levels. Every level when it opens, it's like a rose, it's like a lotus petal. Every stage has again applicability of all the possible sections in that particular scenario. So in this process of issue of warrant, roughly in empirically, we are saying in this particular section that the individual cannot evade justice, has to be arrested by the police, which means every section what we have studied until now around that has to be will be used in this. And the objective is to enforce the accountability and ensure the adherence of the court proceeding happen. And the practical implication is brings a enforcement of the legal order, is abatement of absconding is charged, and a judicial efficiency established. Section 93 talks about the provisions of this chapter generally applicable to the summons and the warrant arrest. So this is a section which says the provisions contained in this chapter relating to summons and warrant and their issue, service, and execution. Everything shall so far as may be apply to every summon and every warrant of arrest issued under this Sanghita. So every summon and every warrant, wherever it is issued, when it is issued, how it is issued, to whom it is issued, what if it is not issued, what extra precautions can be taken like bond, bail, bond, and what happens if that is also not respected, is applicable through this chapter under every such summons and warrant in the mentioned in the Sanghita. And the scope of application is broad. It gives a legal framework signature presence through these sections applicable to, as I said, the lotus petal thing. It is applicable everywhere that particular situation happens at every stage. And it gives a uniformity in the legal process. Like we have seen in the receiver option, it is referred back to the CPC to bring a uniformity in the execution of the law. You cannot define two receivers under criminal and the civil proceedings. It is defined well there, and we utilize it because receiver is something which is primarily a subject area of a civil matter. Because receivers receive properties, either the properties which are confiscated or the properties which are attached, etc., etc., or the properties which is received on behalf of the court for some other reason, or the some kind of money which is received on behalf of the court. So it is defined there primarily for the civil perspective. So the to bring in the uniformity, it is brought back to the CPC. Very same way, this all procedure is uniformly applicable to wherever we talk about the summon and warrant in the Sanghita. It every place, if it is to be issued, the warrant, if the summon is invalidated, if a reason the court believes a bond has to happen, or if the court believes the bond has been not respected, the same sections are applicable there. So this is an authority of the judicial body to provide and affirm that the authority of the courts and their judicial officers are strongly have a strong legal instrument to emphasize their role in maintaining control over legal proceeding, because the judicial officer's role is not only to proceed with the daily proceedings as it comes in front of them in the court, but it is also a very strong ability for the judiciary, the authority of the judicial officers, to ensure they also present a control on the judicial proceedings. So, for example, in the High Court, couple of days back, I was in one court where the person had taken a order from the court where it was the whatever mutual agreement has been done with the husband and wife between them. The agreement was done in line with that, where the wife had uh, given a property to the husband in lieu of their mutual agreed separation, and then whatever the liabilities were there here and there were all done, and the wife has received the property from the husband as instructed by the court, etc. And then the husband very smartly, in lieu of certain post judgment, whatever judgment was given by the court, has gone back, threatened the wife, and again received the property in gift back from her, hiding that fact from the court, and then not appearing in any of the future proceedings. And that proceeding, he was brought with a warrant in the court, and he was provided a warning that you have hidden the salary while you have published in the matrimonial side a different salary for a new marriage, while you present a different salary in the court, and then you have smartly tried to overturn the judgment from the court by smartly pushing the wife to again gift deed you the property to get rid of the future consequences as a private agreement between both the parties post the court proceeding and order. So I think yesterday the High Court has finally given an order on that in justice, one of the justices court there, and they have clearly ruled in favor of the wife, and the court has shown their judicial control that you first come and you comply with what was given in the orders earlier. You cannot play by your own rules after the court has made a judgment by smartly pushing the wife to give back you the property as a gift deed. So he was supposed to return it immediately. He did not did it yesterday. So his property was attached. It was a court receiver was there who will take the property and who will transfer it to the names of the wife, and everything reinforced what was in the court's order originally was reinforced, and the person was punished after that. So this is not only where the court has to go and present themselves as it comes. They have to reinforce, they have to take some strong measures to ensure that whatever is right is established, is the whatever the orders are given are hold in place firmly, or whatever proceeding has to happen, it has to hold firmly the way it has to happen. And that is why these kind of instruments are given, these kind of discretions are also given. For example, we talked about the proclamation, etc., to ensure the presence and the accountability of the people participating in the matter, especially the people who are accused. While the private, some in some cases it might be for the plaintiff as well, because until and unless the plaintiff who is also claiming is not serious about the matter, the court proceedings cannot also happen properly. So sometimes there is an accountability on the plaintiff as well. So this concludes the chapter 4 with section 93 we have read about. Together we have understood the arrest with and without a warrant, exercise of powers of the courts and magistrates, and their execution rules, and proclamation and attachment. Let's go to chapter 5, which is police to report apprehensions, discharge of person, pursue, and retake person under sections 59 to 61. So this is all in chapter number 5, which is arrest of persons. So this is part of chapter 5, which is arrest of persons. So section 59 talks about the police to report apprehension, the very first part of chapter 5, as per the chapter. So the officer in charge of a police station shall report to the district magistrate, or if he so directs, to the SDM. We mentioned this multiple times, the relation why SDM is, the role is there. The case of all persons who are arrested without warrant within the limits of their respective stations, whether such persons have been admitted to bail or otherwise. These cases mostly happen in case of some cases where there is a public disorder, there is a fight, there are a big group of people fighting with each other, and many such reasons where they might have to arrest people immediately for the sake of safety, and then they might have to be released. They might be released immediately after a few hours. For example, there's a normal practice where in the late night, if there is a celebration or a puja and some kind of festivity is going on, and there are parties who are fighting in, they're not in a sober position or etc. etc. The police, it's a discretion to them that they might just arrest them for a few hours and they release them at early wee hours of the morning, say 2 hours, 3, 2 a.m., 3 a.m., so that they go back to their home and sleep by the time the situation is diffused. In that situation, they might also have a possibility under section 189 where they might ask the person to execute a furnish a bond or a bail bond or a surety they have to bring in, and they have to not bail bonds, a bond or a surety, to ensure that they are bringing some sureties or putting some money there, and they are released by the police officer in that case. So all such cases have been an arrest which was made for something which is not even a cognizable offense. Sometimes it might be a non-cognizable offense also. But whenever this happens, a record of that has to be made, and that has to be made available to the district magistrate also. Automatically it goes to the police department. So that is the reason the section does not mention the commissioner has to be informed, etc., etc., because there is already a police hierarchy where it is within the police system, automatically known to the police system. Why it is going to the district magistrate? Because these situations might be exceptional situations when police has to do this, and it has to be in the eyes of the local civil administration also to ensure that they are aware of such situations. So this list has to be given to the magistrate, or if it is a rule given by the magistrate to also copy the SDM, it will go to so and so SDM also. So this section is mandating a police officer's responsibility to report any apprehensions of individuals arrested without a warrant to the district magistrate, and they may also report the SDM as directed. Normally, it is by default, the SDM is also copied. So the provision encompass that all arrests which are making in such situations are regardless of admitted to bail, etc., or not, but it is reported to the people, the collector, district magistrate, or the subdivisional magistrate, not the collector role. We're talking about the district magistrate role, because collector role is a revenue role. So the section establishes an obligation so that the district magistrate is also aware, and this gives a crucial transparency step also, because policing is mostly more crime oriented, where it's very easy to those such do such things which might actually have needed some kind of welfare scheme, some kind of civil administration involvement to ensure these things might not happen in future. So those things are also has to be known to the district administration, and also through the police they should also know whom they are arresting in such cases where they are not supposed to directly arrest and release those person later. So this will also curb the scope of the arrest later, where the unnecessary arrest might be objected, because these are two fangs which work together. And overall the commissioner of police is also is in the law and order areas is subordinately reporting to the district magistrate also. So the requirement covers all cases the person arrested without warrant, and uh, either they are released without bond, bail bond, or with bail bond. And it gives a judicial oversight also, because the district magistrate is also a is an executive magistrate, and whatever the oversight has to be given there, they also look from that site as well. And this is something which is a second eye, which is keeping an eye on the law enforcement activities, which is very, very important, and gives an accountability in the law enforcement at that level. And it's a timely intervention by the district magistrate also, district administration also, to ensure that it was very necessary and it could be justified, then the arrest was made, and otherwise it is not. It might need, as I said, administration intervention apart from the policing intervention also, to ensure such thing happens. Maybe, for example, there are two areas which are religiously completely contrasting. So the two religions are completely contrasting religions, and there are frequently such activities happening between the two parties. And the district administration, if they known this is happening multiple times, and these small things are happening again, and then record is being sent to them, they might come back and work with the local administration, government also, to ensure probably there is a wall which is created between both the localities, which will need an administrative side. Police cannot go ahead and funds, or they don't have a ability to ability to make a wall. So that is an administration role. So this is one example. There could be many things. Plus, there is an oversight on the police, because these things could be considered as something which is done in contravention with the liberties given by the people to the by the constitution, and police is might be blamed later on that. So, or maybe police is actually doing that. In that case, there is a control in those cases, where in such cases there is a control by the district administration in such situations, and that is what is signified by this particular section. Section 60 talks about discharge of person apprehended. So, no person who has been arrested by a police officer shall be discharged except on his bond or bail bond, or under the specific order of a magistrate. So, the person who is arrested by a police officer shall be discharged except on his bond. So, when we see section 59, officer of the police station shall report to the DM, or if so directed, to the SDM, the cases all person arrested without warrant within the limits of the respective station, whether such person have been admitted to bail or otherwise. So then on addition to that, it says no person who has been arrested by a police officer shall be discharged except on his bond or bail bond, or under the special order of a magistrate. So either he writes on letter, signs on it and says, okay, I'll not do it again, or he gives a financial bond with surety or without surety, or the person has to released on a magistrate's order. So which says the condition for discharge is the provision established a strict condition under which an arrested person may be released, ensuring that person are not arbitrarily or unjustly freed without appropriate legal processes. So if the person is arrested, the arrest, it is it is signifying the reason of arrest, which means it is putting the accountability on the shoulders of the police, that if you are arresting somebody, it is definitely because of some very strong reasons you have arrested. It is not an arbitrary or a some kind of arrest which is unjust. So if you are doing that, so definitely you will have an option to on records keep the first of all things and pass it on to the district magistrate also. And then you will also have a at least a bond, which is a piece of paper where the person is promising that, uh, of course, on a particular tools which are required to be used in terms of the administering such kind of or presenting such kind of bond, but using the same legal process, but it is signifying that the arrests are not arbitrary or unjustified, because if you are doing that, you are creating a record first in section 59. So then police will also think twice the procedure, the reason for this. What happens is different story. So section 59 is something which is in that direction, that the record is should be there. And for that reason, every police station nowadays have a cameras also on top of that. Because if the records are mismatched, if the person was held in the police station, arrested for some time also, and if there is no record in that list, then there is a problem. So for to curb all those things, there are further various procedures, various protocols, etc. So the 60 section 60 discharge of the person, whatever option is given, is signifying what exactly, that the arrest is not unjust. So if the arrest is not unjust, the person should not be released freely, because until and unless this somebody is arrested for some reason, at least a bond has to be signed by the person. Up to the level, it has to be released with the help of a judicial oversight if required, and that is something to ensure that the person also learns a lesson and he's reprimanded strongly, and he's avoided in future to commit such offenses. And even if he does so, there is a record of that which is available, which becomes a difficult situation for him in case such bonds, bail bonds, or such other magisterial bonds are discharged against him. So this is a special order of a magistrate, highlight that the importance of judicial oversight is also mandated there. So it encourages with compliance with the legal procedure. Although it says that you take a bond, you take a bail bond, or you bring that person to a magistrate. Section 189, 190, we spoke about that. But then it is in a way enforcing the strict legal criteria for arrest also to the police, because if they are discharging under rule, they have to arrest also under rule, because both has to be in same line. So this is a protection of a legal right of common people also, while it is preventing an unlawful arrest as well as an unlawful release also. Because if you have arrested somebody lawfully and the person is vanishing without any record of such arrest in the list sent to the district magistrate, or there is no at least bond available, which means a unlawful release by some gratifying activity by the person has been done. So the police has released that person happily. So that also has to be prevented, because if the machinery of the law has been executed, the record has to be created. A shadow of his past has to be shown. And as I mentioned earlier, now Supreme Court has mandated for any such bail applications in future in front of any magistrate, all the previous guilt of the person, all the previous criminal record of the person has to be presented. So that becomes a far more difficult thing for person if the section is complied properly, section 60. So it encourages a proper documentation also, and end of the day sums up everything to the effectiveness of the police, so that whatever they are doing is actually what is required to be done. And if it is done as per the requirement, it is then resolved as per the requirement as well. The person cannot be set free just like that if the person has committed some offense, major or minor, does not matter. The section 61 talks about power on escape of pursue and retake. So in this section, if a person in lawful custody, now the person is in lawful custody for whatever reason, escaped or is rescued. So when the person runs away himself, which is escape, or a person is rescued, some of his team members come, some of his gang members comes and rescue him from the police. It's a rescue, right? He's in custody of the police. He has to be rescued to freedom by his people. So the person from whose custody he escaped or was rescued may immediately pursue and arrest him in any place in India. So the person from whom it has been, on whose custody he has been lost, he has run away or he has been taken away, the person has to go find him and has an authority to find him in any place in India. Subsection 2 says the provision of section 44 shall apply to arrest under subsection 1, although the person making any such arrest is not acting under a warrant and is not a police officer having authority to arrest. So what is section number 44 title is the search of the place entered by persons sought to be arrested. So the provisions of the section 44 shall apply to arrest under subsection 1, although the person making any such arrest is not acting under a warrant and is not a police officer having authority to arrest. So even the person who was not supposed to be an authority to arrest that person, or any warrant was not given, still this section empowers him. If he runs from his clutches of his custody, he can go ahead and use section 44 to apply and to arrest the person. What does section 44 says? He can go and search in their premises. He need to be taken support from extended support from the person owning that or controlling that premises. He can break the inner outer doors. He can break the windows. He can make the search happen with help, and then he can also somebody who can rescue somebody if he sees and finds in that location to be uh, uh, you know uh, locked illegally, confined illegally, detained illegally, and he can also break the windows and doors and come out if he is also trapped inside in the operation. So authority to pursue the arrest is given to the person in whose custody the individual is accepted. Automatically all those authorities are given to the person, and immediately he has to pursue the arrest, because until and unless law is not empowering him with all those powers of a person who might be looking for him by law as per warrant, with a warrant and as a power to arrest, he will be toothless. He has to go back and report to the person, again go and invoke the machinery, and it might be a time lost and the person lost. So this provision ensure that the responsible for maintaining custody have the plenty of ability to act swiftly on to reclaim the escaped person, because finding somebody after some time and reclaiming immediately, chasing and trying to find is quite two different things. So the scope of the application is the right to pursue and retake is not limited by a geographical barriers. It is not limited by any delegated authority of warrant or arrest. It is automatically invoked the moment the person runs away and across the India, and taking the urgency, the lawful custody is broken, the person has full rights to arrest. There is a judicial backing also given, where section 44 is automatically attached to this section, where he has got all the powers to arrest without warrant and all the powers which a officer will have to search and find that person. So it empowers the custodians, the police officer who is custodian. This empowers him and discourage the rescue and escape, because there is no other permission required. The person will immediately be after you. And the clarity of a non-police officer is also given as here, that by allowing a non-police officer also to effectuate a rearrest under certain circumstances is what which is possible by the obligations of this power given to through section number 44. And for your memory, I'll just quickly read that the search of the place entered by person sought to be arrested is the person has to be who is ingress in such places cannot be obtained. Section 1, lawful for the person to acting under warrant, and in any case to warrant may issue be cannot be obtained without according the person to be arrested. Appropriate escape for a police officer, etc. So they can have enter that person. Believe the person to arrested has entered into within the place. Any person residing being charged of such place shall on demand of such person. So they have to have a free ingress, and they can go and break inside and ensure that they can make an arrest. And we talked about in the special exceptions also in this area, where if a lady who cannot show herself in person uh, as per the custom, etc. So all those things are applicable. So we spoke until chapter 5 today, which is section 59 to 61. Tomorrow we again start further with chapter 6, which is right of arrested person, and then the prevention powers of the police.